Donald Trump's criminal defense lawyers filed this motion today in the Washington, D.C. case brought by Special Prosecutor Jack Smith for Donald Trump's conduct leading up to and on January 6th in his attempts to overturn the presidential election, basically the case that mirrors the charges in Georgia. And Donald Trump's defense lawyers in this case believe that Jack Smith's request for a trial next year is too soon. They would like to spend all the rest of this year studying the evidence of the case. They would also like to spend all of 2024 studying the evidence in the case. And after that, they'd like to spend all of 2025 studying the evidence in the case. And they think, after all that, they will be ready for a trial in April of 2026, just about 3 years from now. They insist that the amount of evidence in the case is overwhelming. Here is one description of it. They say, even assuming we could begin reviewing the documents today, we would need to proceed at a pace of 99,762 pages per day to finish the government's initial production by its proposed date for jury selection. That is the entirety of Tolstoy's War and Peace, cover to cover, 78 times a day, every day, from now until jury selection. Andrew Weissmann, speaking as someone who's never finished War and Peace, even once, it sounds like they have a point.
They have a point in that due process requires that they be given sufficient time to prepare. I wouldn't be surprised if Judge Chutkan does not go with the date that was proposed by Jack Smith. But if you've been in the criminal or civil justice system, and of course Judge Chutkan has been in both, she knows that this is not a memorandum that's geared to her. And the reason is, under this reasoning, the Enron case, which I prosecuted, would still be awaiting trial. The Mueller cases, which I keep on using the Manafort case as an example of a D.C. case that went to trial within 11 months, we'd still be waiting for that. Page-by-page review is no longer done, and whether in civil cases or in criminal cases, because of the vast volume of electronic data. You do electronic searches. That is just commonplace in all of these courtrooms. Judge Chutkan knows it. The defense lawyers know it. The prosecutors know it. This is written for someone else. But having said that, the real issue for her is, what is the delta of additional material that the government is turning over, and how much time do they need to look at that material? Because remember, they've already gotten a lot from the January 6th committee, as we all did. So that delta is, I think, what she needs to be focusing on, and making sure they do have enough time to master that evidence and present it. In terms of what their defenses are to it.
Amy Lee Copeland, as a criminal defense lawyer, I don't know how many times a day you've had to read War and Peace, but this does sound like a pretty heavy burden that they have. How much time would a judge reasonably give them for this?
I think they'd be better off asking for about a year from the date of indictment. One of the things at play in a federal case is a defendant has a right to a speedy trial, but the public has a real interest in a speedy trial too. And given this case and the public interest in it, they really do. We've got a guy who's in a presidential race, and this case needs to be decided sooner rather than later. This needs to be an accountability test. The April 2026, I agree with Andrew, that was written for another audience that wasn't the judge. But the judge will do something more realistic, will consider the speedy trial factors. And my best guess is going to be about a year from the date of indictment.
Gwen Keith-Fleming, all of these judges at this point in this case must be looking at every one of these filings, taking note anyway of every one of these filings. This certainly tells the judge in Georgia what kind of a trial date to expect there. I mean, they're talking 3 years from now in the Washington case, so they'll be asking for something similar to that, no doubt, or more in Georgia.
Well, it may very well be that each judge is watching or having their clerks identify the different timelines. But let's remember, these are, first of all, two different jurisdictions, state and federal, and at least three or four different judges, each of whom is going to have their own way of managing their docket and their own responsibility to the constituents, much like Amy Lee indicated. And so while there may be an awareness, I would be surprised if that awareness would really influence any particular judge to try to avoid the time schedule of another judge's calendar.